2022 CR 6548, State of Texas versus John Anthony Ayala. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Michael Collins, attorney for defendant, present and ready, Your Honor.
All right. And are you John Anthony Ayala?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same John Anthony Ayala who was placed on deferred adjudication in 2022 CR 6548 for the offense of indecency with the child act on January 17th, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, violated condition number 3, on or about the 22nd day of February, 2024. In Bexar County, Texas, the defendant, John Anthony Ayala, did then and there fail to obtain and keep gainful employment in a lawful occupation as directed by the court and or supervision officer in violation of condition number 22.
All right, is this on the amended?
Well, I think it may have been a cross-reference, Your Honor, but it should just be a violation of condition number 3, given that it was an employment-based.
All right, any objection to the state adding that it's not a violation of condition number 22, but a violation of condition number 3, counsel?
No.
All right. So how do you plead to a violation of condition number 3?
True.
All right. State,
And Your Honor, the state will waive and abandon the other.
any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 3, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 3?
Yes, ma'am.
Court will find violation of condition number 3 true. Is there a proposed agreement?
There is, Your Honor.
Yes, Your Honor.
All right, and what is the proposed agreement?
Your Honor, we agreed that my client would go to State ISF for 90 days, Your Honor, then return to the SOMU upon release. GPS for 1 year through Bexar County Jail work release, waive the fee. No internet accessible devices for duration of probation. No internet accessible devices for duration of probation. Require a haven for hope if homeless and zero tolerance. He's not homeless. His mother has a place for him.
All right, so can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
John Anthony Ayala.
All right, why do you not have employment?
I had tried applying to different places, but I either got the runaround or they just never contacted me back.
And his mom is present with proof of 2 places that he did apply, Your Honor.
All right. So we want ISF. What is probation's recommendation?
That is a recommendation.
No.
John Anthony Ayala?
Yep.
All right, so he's pled true to not having employment. How is ISF going to help things, or are we doing ISF because there are other things in the motion that are not being addressed?
Yes, sir.
Okay. All right, any objection to the court reading the court summary?
No, Your Honor.
Okay, after reading the court summary, my question is, why shouldn't he be revoked and go to prison? Because obviously he doesn't want to follow the rules.
Well, his information to me, Your Honor, is that as far as having other devices, said he didn't have them. His mom is here to say that he had a flip phone that was not internet accessible, Your Honor.
Well, I mean, obviously, if they're saying that there's history of what he should not be viewing, whether it's a flip phone or not. I never had a flip phone, but obviously it's showing a history. Are we saying it's not showing a history?
We're not pleading to it.
Or is he saying are you saying his mom was in possession of pornography?
No.
So I don't understand why should you remain on probation? It appears as though you don't want to be on probation. I see what they're asking for and what their recommendation is for, but I just don't understand why you should continue to be on probation. So do you wish to go to prison?
No, ma'am.
It appears that you do, though, by your actions.
Since being locked up, it's been a real wake-up experience for him, Your Honor. He's not been in this situation before.
I mean, he's looking at 20 years in prison.
Emphasize
I
it to
mean-
him, and yes, he
I think that should be a wake-up call.
understands where he's put himself, Your Honor.
Now, it's not pornography, but it's saying it's pornography and you're not supposed to be viewing it. So the question becomes, is watching pornography worth 20 years of your life potentially?
No.
It seems that you think maybe it is because they're saying they admonish you on February 7th, 2023. And then they admonish you again on April 25th, 2023.
I could only think of one time when they.
No, they said that they admonish you on February 7th and April 25th. So your question becomes, is pornography worth going to prison over? Potentially. I keep an open mind, but
No.
you have a choice. Either you can watch pornography and potentially go to prison, or either you can not watch pornography. Do you understand?
Yes, ma'am.
So do you want to watch pornography and potentially go to prison or not watch it?
Not watch it, ma'am.
All right, probation, this is what you all are asking for? And state, this is what your agreement with?
I think the like lack of clear details with respect to the phone, and it had porn on it, but then they were watching it. It's not of a. The state was okay and amenable to going through this and making it a last leg, what would otherwise be a very long journey for this individual.
All right, he's joined ISF Cognitive. Then he is to return to the sex offender unit. There's to be GPS until further notice. And that'll be partial for work only. Waive fees. That's what they put in the probation recommendation. And you're not to have any access to the internet. Or internet devices. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am.
All right. You better do better.
Yes, ma'am. I plan to. I have plans to reapply to different places where I was denied or never contacted again from the same constant contact with them
And not watch porn.
and not watch porn.
Okay. Thank you. Holly, 2024 CR 0411, State of Texas versus George Cantu. Can I have the parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defend.
Alfredo Ortiz for the defendant, George Cantu, Your Honor.
Are you Mr. Cantu?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, as a habitual.
Yes, sir.
And so this tampering with electronic monitoring device, what is that, a third degree?
It should be state jail, but
Okay,
I was looking into it. I know that the statute does have the third degree language, but
Mhm.
that's it. It was a intensive supervision. And there was no language like that in our side.
okay. All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with an electronic monitoring device under intense supervision? That's a state jail felony, the way it's been indicted. The range of punishment normally would be anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, you can unfold your arms. You get people nervous when you do that, okay? If the state is able to prove up the enhancement allegations, then this would be a second-degree punishment. The range of punishment would be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am. Court
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it? The plea punishment is to be assessed at 5 years in the prison. You agree that you've been convicted of 1 or 2 more felonies for enhancement, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
George Canu is charged with tampering with a GPS monitor, which is usually a state jail felony, a slap on the wrist with 180 days to 2 years. But because he has prior felony convictions, the prosecution dropped a habitual offender enhancement. That's the law working exactly as designed. Repeat offenders face exponentially stiffer penalties. He's pleading guilty to get a cap of 5 years. But is that actually a win? Or is the state just boxing him into a corner with no way out?
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there has not, Your Honor.
And did you understand that to be the plea, a cap of 5 years?
That's correct.
All right. And state, is that the plea, the cap of 5 years?
Yes, yeah.
All right. And to correct the record, the plea offer is for a cap of 5 years in the prison. Did you understand?
Yes, ma'am.
All right. And to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State, any evidence?
State offer states to the one in all fashions.
Any
No.
objection?
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. And with regards to the both paragraphs of the habitual offender enhancement allegation, how do you plead, true or not true?
True.
And that's true to both of the enhancements?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Do y'all wish to proceed with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We filed a motion to reduce this state jail felony to a misdemeanor punishment, Your Honor, 1244A. We want the court to consider the circumstances regarding the the offense, Your Honor. November 7th of last year, Mr. Cantu informed his parole officer that he had problems at home, and that he was living with mom and he couldn't stay there no more. So he informed his parole officer that he was gonna take off, unbuckle his GPS monitor, that he couldn't stay there no more. That was November the 7th. He left the equipment there at his mom's house and that was not damaged or anything. 10 days later, November 17th, he self-surrendered to the parole officer. And he was taken to custody and taken to the Bexar County Jail, where he has been there since he was arrested, Your Honor. I want the court to consider that he is not a violent person. He has the criminal history that he has, a lot of it can be attributed to his drug abuse illness. He has never received any treatment for that, Your Honor. So we're asking the court to consider all these factors and sentencing Mr. Cantu, Your Honor, and sentence him to a year in the county jail, Your Honor. And I think Mr. Cantu likes to address the court.
All right, so legally, this cannot be a 1244. So you want to raise, I'm sorry, you're already under oath. So it says in the police report that the device was removed on November 7, 2023, and it was reported as being removed on November 8th. And when I say reported, that's not you reporting it. That's just parole became aware. So what would you like to say?
Well, I took the monitor off on the 7th, and the warrant was issued, I think, to the 8th, the next day.
Okay. And did you turn yourself in on the 7th?
Yes, no, 17th.
All right. Any questions?
What do you like to say to the judge regarding sentencing?
I mean, I just got a surreal drug problem, a bad drug problem, and it really needs help, Your Honor.
Is that why your mom didn't want you living with her anymore?
Yes, doing drugs.
Okay.
I'll pass the witness.
Nothing to say, Judge, just sorry.
All right. Well, what I can tell you is I've done parole hearings in my past as well. And I know, and you correct me if I'm wrong, all you have to do is pick up the phone and call your parole officer. And in actuality, I think parole is easier than state probation. So did you pick up the phone and call your parole officer and say, I'm in the throes of my addiction. I need inpatient treatment?
No, ma'am.
Did you call them at all, telling them that you needed help?
No, ma'am. Called them after, cut it off.
Okay. All right. This is what the court is going to do. The court is going to find you guilty. Court is finding the enhancement's true. The court is going to sentence you to 5 years in the prison, give you credit for any time served, and this will run concurrent with parole. Showing you what's entitled defendants' rights. I'm sorry, trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So I want to let you know that I did listen to your attorney's argument. I always internalize what I'm hearing, but at some point you got to be responsible for your actions. You understand? All right, good luck.
All right, wrap up time. 2 cases, 1 lesson. Probation is serious. Ayala, a sex offender, risked 20 years for broken rules and explicit content. He got one last chance with strict conditions. Cantu, struggling with addiction, cut his GPS and surrendered later, but his criminal past triggered a habitual enhancement, landing him 5 years. Judge Boyd gave both fair hearings. The takeaway? Courts give chances, but they expect accountability.